I'm Janice Fiamengo of the University of Ottawa. My message is for mothers of sons who are starting or returning to university classes this month. My question: is your son safe on campus? Do you know what kind of sexual assault policy is in place at his school? Specifically, do you know what procedures have been adopted for dealing with a complaint of rape or sexual harassment against your son? Do these procedures include due process and the presumption of innocence? And does it matter to you? For feminist mothers in particular, I would ask, are you happy with the idea that your son could be found guilty of rape and expelled from his school according to the feminist doctrine that a woman's word is sufficient, that women never lie about rape? The United States Department of Justice recently issued a press release announcing funding in the amount of $8.5 million to reduce sexual assault, domestic violence, dating violence, and stalking on college campuses. Here's part of what the press release states. Recipients of the grant money are required to conduct mandatory prevention and education programming for all incoming students and to train campus law enforcement and all members of campus disciplinary boards to respond effectively. Campuses can use funds to develop and adopt policies and protocols that prioritize victim safety and hold offenders accountable. There's a list of schools at the bottom of the press release that have accepted the funding. And to be fair to the schools, it should be said that they're under intense pressure from the government, as are universities in Canada, to institute such policies and procedures. If they don't do so, they risk serious sanction. In other words, this is a mess that is not necessarily of the university's own making, though it has certainly been capitalized upon by feminist activists and their allies within the university system. There are a couple of things to note about the press release. First, we have the reference to mandatory prevention and education programming for all incoming students. We've seen what that looks like already at prestigious universities such as Columbia U, which has a mandatory sexual respect and community citizenship initiative, not only for incoming students, but for all undergrad and graduate students. What are these prevention and education programs all about? Well, they all begin from the premise that rape, rather than being a relatively rare crime carried out by deviants and deplored by all right-thinking people, is a widespread male behavior, part of rape culture. According to these programs, rape is the way men assert power over women in a society of structural social inequality. Although not all men rape, all men benefit from rape, according to this theory, by keeping women in a state of fear. The message of these sessions is that in any sexual encounter, the woman is a potential victim, even if she appears to give her consent. The man always at least potentially guilty if she was drinking alcohol, if she regrets the sexual experience afterwards, and even if she didn't enthusiastically consent at every stage. The message of such programs is that male sexuality is by definition linked to violence and subjugation. Female sexuality, in contrast, is to be celebrated and protected. These programs are a powder keg of unproven assumptions, victim fantasies, and blatant male vilification. Perhaps your son is resilient enough to shrug off the flagrant bigotry of such indoctrination sessions, though the rising suicide rate and incidence of mental illness amongst college-age men suggests that many are being adversely affected by all this shaming and blaming. But what happens if your son actually becomes the subject of a complaint to a university tribunal on a charge of non-consensual sex? Here things become very Orwellian very fast. Notice how the State Department describes the purpose of its policies and procedures, which is to, quote, prioritize victim safety and hold offenders accountable. Note that there's no presumption of innocence here. So if you thought impartial judgment, the judicious weighing of evidence, or the protection of the rights of the accused would matter to such university bodies, you'd be wrong. This is an initiative of the Office of Violence Against Women, after all, where women are assumed to be victims the moment they make a complaint, and where the men complained about must, by extension, be the offenders to be held accountable. There is reference in the press release, to be sure, to training for those who will make judgments affecting your son's standing at college. But this won't be legal training. These people are not lawyers, and they know nothing about how to investigate a criminal charge, conduct interviews, weigh evidence, examine and cross-examine witnesses, and so on. The emphasis is on prioritizing victim safety. In other words, the victim will not be rigorously questioned, her version of events will not be cross-examined, and counter-evidence by the accused will be regarded with suspicion or even ruled inadmissible. These disciplinary boards are by definition on the side of the victim, not the accused, and as a result, it can all too easily happen, as has happened, that male students are found guilty with no evidence except the accuser's claim, and frequently in the face of tangible evidence to the contrary. In 2013, Judith Grossman, an American lawyer, published in the Wall Street Journal an account of her son's ordeal at a small New England college. Grossman's son's experience is typical of what happens to a young man under investigation. He had to appear before a campus tribunal with just a couple of days' notice and without precise details of the charges against him, based on incidents that had occurred years earlier. He was denied the right to have a lawyer present and was not allowed to bring counter-evidence, details of the relationship, including emails and other correspondence. He was not allowed to confront his accuser or the witnesses against him who were friends of the accuser, who corroborated her story. Fortunately, in his case, the charges were dismissed, perhaps at least partially because, as a lawyer, Grossman was able to coach and assist her son behind the scenes and to prepare his defense. I expect that she also brought some pressure to bear on the university administrators. In her article, she recognizes the likelihood that other young men, less fortunate, without her son's support system, would have been found guilty under the preponderance of evidence model in use by these tribunals. That means that guilt does not have to be established beyond a shadow of doubt. The tribunal must simply find it more likely than not that the alleged incident took place. It is staggering to consider how many men have thus been found guilty of assault merely because it seemed likely. Some of these men are now coming forward to clear their names, suing the universities for wrongdoing. Grossman makes a point of stressing her feminist allegiance and how the experience has shaken her confidence. She says, "Until a month ago, I would have expressed unqualified support for Title IX and for the Violence Against Women Act, but no longer." Well, frankly, I don't know where Grossman has been living for the last few years, but never mind. It's too bad that it took a charge against her own son to wake her up, a charge that might have resulted in his life being ruined because of her misplaced confidence in the feminist movement. But at least she's had the good sense to understand why the new sexual misconduct policies are so egregious, not only for her son, but for other young men equally or more vulnerable to a false charge. Grossman's article suggests the answer to the question, how could it happen that in a few short years such policies could go from being the triumphalist fantasy of feminist ideologues to the sledgehammer reality of schools all across North America? It happened because a lot of feminist moms supported Title IX and its various equality provisions, never thinking about how, in a culture of man-blaming, they could be so shockingly abused. Some mothers are now speaking out. A group called Families Advocating for Campus Equality, a small group of California mothers, has begun distributing flyers to young men on campuses, warning them about the bizarre situation that now exists. The flyers tell students, if she has touched alcohol, do not touch her. The flyers also advise students to, quote, document and save her consent. Never delete email or text conversations. Your college will treat you as guilty under current interpretations of Federal Title IX, the flyers state. Students are advised to consult a lawyer as their school, quote, will not help you prove your innocence. Prepare to fight for your future, they exhort. One can only hope that the numbers of these concerned mothers will swell until university administrators can't afford to ignore them. One can only hope that, ashamed before the rising tide of outrage at the injustice being done to men on university campuses, administrators and government officials will disband their disciplinary boards and will rethink the whole manner in which claims of sexual assault are handled. For those of you thinking about your daughters, worried about the alcohol-fueled hookup scene on so many university campuses, yes, that's a legitimate concern. But there's no security for young women in a biased and slapdash disciplinary panel inclined to find men guilty. If your daughter ends up ashamed and confused after one or more sexual encounters with boys she barely knows, her humiliation and lostness will not be healed by making a false allegation of rape. We do young women no favors in encouraging them to take no care for their own sexual well-being and then to betray others and themselves with self-justifying lies and fabricated innocence. Ruining the lives of our young men will do nothing to redeem the sexual brokenness and emotional sterility of our present cultural moment. So come on, moms, get ready to fight for your sons.